Thank you, Mr. Chairman, and Judge, thank you for your time. Senator Grassley asked you about the Second Amendment, and you said that you agreed it was a fundamental right, correct?
Yes, the Supreme Court held that it is a fundamental right.
So in that light, do you believe that the Second Amendment should be held with the same seriousness as the First Amendment?
Yes, Senator, constitutional rights must all be respected and implemented in accordance with Supreme Court and, in my case, Second Circuit precedent.
No concerns about Second Amendment rights for the individual?
Senator, I have no concerns about applying Supreme Court and Second Circuit precedent in this area or any other.
Okay. I have to tell you, there are a lot of Tennesseans who are very concerned about some of the judges and the nominees that are being brought forward by this administration, because there seems to be a tendency to pick and choose what rights you want to say, I agree, in the text for this one, but not for that one. And so it's important to Tennesseans. Let me ask you about your judicial philosophy, both in terms of statutory interpretation and constitutional interpretation on that. How would you define judicial activism when it comes to some of these decisions? And how would you address the concerns that Tennesseans have about this subjectiveness that some of the nominees are bringing forward in their comments to us?
Senator Blackburn, on the question of the meaning of judicial activism, I think, of course, that could mean different things to different people, but I think the pejorative meaning, the meaning that people are concerned about, would be some notion of a judge substituting his or her own policy or personal views in the course of the function of judicial decision-making, whether it's interpreting the Constitution or statutory provisions or otherwise. If that's the meaning that folks are concerned about, and I suspect it is, there's no role for that.
Well, let me move on to political activism, because you've been very politically active in your career. 2004, you served as Associate National Counsel to presidential candidate John Kerry. You served on the Obama administration DOJ transition team, the Obama-Biden campaign for change. You served as a volunteer lawyer for the Maryland Democratic Party. All of those are correct, right? And also for the Democrat National Committee.
I'm not, the Maryland Democratic Party, I'm not.
Yeah, you served as a volunteer lawyer for the Maryland Democratic Party and the DNC. So let me ask you this. When litigants appear before you, how do they know that you are not going to exercise some of your political activism as you look at their case?
Senator Blackburn, I've been a judge for about a decade now. I gave up my prior role as a government lawyer, as an academic, as a lawyer in private practice, and my volunteer work that I had done on a variety of campaigns. Like a lot of judges who come before me, that was part of my prior career. I gave that up.
Okay. Your release of some felons during the COVID-19 pandemic, and I've been watching the hearing up in my office. I don't think anyone has asked you about this, but several of those that you exercised compassionate release for, they were violent criminals with violent histories. In some of the cases, the criminals had already been vaccinated or had already contracted and recovered from the virus, or their prisons had no confirmed cases of COVID. Recently, there has been an increase in violent crime and highly visible smash and grab robberies that are just plaguing so many of our cities. And releasing violent criminals will only further endanger our communities. And so I would like to hear your justification for this decision to release violent criminals and to say this is a compassionate release, because I know retailers don't see this as compassion, and communities, a lot of security moms don't see this as compassion.
Senator Blackburn, I had, like many judges during the pandemic, many petitions, requests for compassionate release. By and large, I denied those, and where I did deny them, it was largely on the statutory factors determined that the individual was likely to be a future danger. And the instances in which I didn't, I evaluated the factors under 18 U.S.C. Section 3553 and in conjunction with the compassionate release statute.
Thank you, Mr. Chairman.
Thanks, Senator Blackburn.